Hello everyone. Thank you for your patience. Apologies, I said there was a little mistake in the program which caused some running, so you will kindly give our speakers a moment to have a glass of water and a deep breath. And in the meantime, I will introduce our panel. So, thank you again for being here at this panel discussion on AI and children's privacy, challenges and regulatory approaches. My name is Leanda Barrington-Leach. I'm the Executive Director of the Five Rights Foundation. We are an international NGO with the mission to build the digital world that children and young people deserve. So some of you may know us from our extensive work on children's data protection. Others may know us from our work on the AI Act or the Council of Europe's Treaty on AI, but either way, you will know that children's privacy and their rights and safety when interacting with AI are a top priority for the Five Rights Foundation, and hence our desire to explore this topic with you today. So why is focusing on children so important? Well, under 18s globally make up a full third of internet users, and they have very specific needs as well as very specific rights. AI is ubiquitous in their online experience and increasingly impacts their development and their daily lives. For example, recommender systems driven by AI shape their worldviews from a very young age. Algorithms constantly target them with nudges, drawing them away from their studies, play, and sleep. 4/5 of teenagers use generative AI, and 2/3 of teachers believe it does a substantial part of the homework. AI is more generally increasingly used in schools for tasks from access to grading to attention and emotion monitoring. So there are clearly opportunities, certainly, but there are also serious developmental and safety concerns for children at stake, from addiction to bullying to sexual exploitation. And in this room, I hope, few will be surprised to hear that there are serious privacy concerns. 74% of AI apps share users' data with third parties, and the Mozilla Foundation recently found that one romantic chatbot delivered at least 24,000 trackers within 1 minute of using the app. Five Rights' research into edtech systems has also demonstrated how children's data from the classroom is also being widely shared. So that's why we're here, to talk about what needs to be done and what can be done and how to do it. So let me introduce our panelists. I'm going to go in the order that they are going to speak to you. So starting with Monsieur Xavier Delporte, who is clearly a very serious data protection expert with over 22 years at the CNIL, the French Data Protection Authority. After heading the compliance practice, now Xavier works on relations with the public, if I understand well. We will then be hearing from Sophia. Sophia Ignatidou hails from the ICO, the Information Commissioner's Office, so that's the Data Protection Authority of the UK, which is well renowned as a world leader on children's data protection. Sophia heads the team on AI and is the author of the latest guidance on AI and data protection. Then we'll be hearing from Elisabeth. Elisabeth Dehareng is a partner in the ITC and IP practice of Baker McKenzie's Brussels office. She advises clients across all areas of technology law with a special focus on privacy, cybersecurity, and AI. And last but not least, Dr. Ansgar Koene is the global AI ethics and regulatory leader at Ernst & Young. Ansgar does a lot of work on standards, both at the European and the international level, and very interestingly has a multidisciplinary research background with an MSc in electrical engineering and a PhD in computational neuroscience. And Ansgar is also the vice president of the board of the Five Rights Foundation. So, with those brief introductions, I am going to hand the floor to Xavier. So, Xavier, more than 20 years experience with one of the most active data protection authorities in Europe. So, how about telling us a bit about your experience, and is our AI really so new and disruptive, or can we use GDPR to rein it in particular for children?
Thank you very much, Leanda. Despite my 22 years at the CNIL, it's my first time at CDPB, so thank you for the invitation. I'm very happy to be here. To answer your question, no, AI is not so new. we use it in our daily lives for many, many purposes, with many different apps. It doesn't work. Oh, thank you. Sorry. So I was saying, despite 20 years at the CNIL, it's my first time at CDPB, so thank you very much, Five Rights, for that invitation, and I'm very happy to be here with you. So to answer your question, no, AI is not so new. We use it in our daily lives for years, and children too. You talk a little bit about it, but they are very fond with some vocal assistants who can respond to the questions they don't want to ask their parents or their teachers. They do not know as adults that they use AI, but it's still here. And AI needs data to work. Not always personal data, but yes, a lot of personal data. We had what we call a revolution with generative AI that use more data than ever, and maybe more personal data than ever with scrapping the web. The thing is that despite that revolution, it's under privacy rules because it uses personal data. So it's quite a revolution in a technological way, but we still have GDPR within the EU, and it applies to these AI systems, the old ones and the new ones. And what is interesting for children is that GDPR recognizes vulnerability, and so there are different provisions in GDPR that protect children. And so this protection applies to AI systems. There is no AI exceptions in GDPR. If you process personal data, you have to comply with GDPR. But GDPR is not, and it was maybe a few days ago, but today it's not the only legal text in Europe about AI, because yesterday, as I'm sure you all know, the AI Act was definitively adopted in Europe. And we are, it's not just in the EU, but the first international treaty on AI by the Council of Europe last Friday. These are not text about data, it's about AI, and it's not really speaking about children. But the GDPR does. So to protect children, to protect their privacy, to protect their rights, because I like to remind that children have rights, they don't know it. Adults very often forget that children have rights, but they have rights, and GDPR recognizes that. So privacy is still in the game. And of course, you have to take it into account when you create processing, when you process data, when you create an app, a website, when you, with or without AI, you have to take account that children can use it. The fact is that generally, websites, apps are created by adults and for adults. They don't think about children that can use it. And that's maybe where the problem is, because children, you don't know what they are doing to do, because they are children. And one day they can find your app or your website and decide that's really cool, really nice, really helpful. And it will be a major success for all the kids in one country, 2 countries, all over the planet. And you will have issues because you didn't think at the beginning that children could use it. So it's important to have regulations. It's important to have in mind that GDPR is protecting children even with AI systems. But, and I think we're going to talk about that, regulation is not everything. It cannot do everything by itself. We need our developments, our tools, and all the stakeholders taking part of the need to protect children. Because, as I said, when you develop an app, if you don't think that children will use it, you won't protect them, and the day they use it, they won't be protected. And children are vulnerable many more than adults, and they are the future of our society. So we have to protect them, we have to recognize their rights, and we have to think about them, even if we think they are not our target. So I talk about GDPR and privacy rules that protect children. Of course, data protection authorities have to take that and transform that principles into actions. That's why, for the CNIL in France, protecting children is one of our priorities. We have not a new chairman, but our chairman has a new mandate until 2029, and she said that protecting children will be a priority. It is a priority by giving advice to companies that want to develop AI systems or other tools that can be used by children. We work with the French Ministry of Education because, as you said, in the education sector, there are major issues with protecting children, privacy, with all the tools, and we know that we have more and more tools with AI in education, and it's, I don't know in other ministries, but in France, there are not a lot of AI specialists at the Ministry of Education. So they need help, and of course, enforcement, because as a data protection authority under GDPR, we have some powers. We can control, we can impose fine. So we already started to investigate about some cases. I can't say a lot about it, just let you know that we are working on it. And in my department, as you said, I am relations with the public, so we do privacy literacy, and we go into classrooms to meet children, to discuss with them what they do, and they say to us things. They don't say their parents, they don't say to their teachers, they don't make complaints to the CNIL. So we learn things, and that things we learn on the ground can be ideas for our colleagues from the enforcement departments. So yes, privacy. AI is not new, and privacy is a good tool to control that. Thank you.
Thank you so much, Xavier. I hear very strongly from you, indeed, that privacy remains and data protection remains a key tool, and that it needs to be taken into account, and children and their rights, and they need to be taken into account from the start, including in system design. and that you're listening to children and enforcing. So very excited about that. So thank you for that. I'm sure we'll come back on some of those points. Sophia, let me turn to you. So as I mentioned before, you lead the AI team at the ICO, where you have developed a particular framework called the Age-Appropriate Design Code to implement GDPR for children. So with that in mind, why is that important? Why is it important to govern AI from a children's rights perspective, and how does this play?
Sorry, is this working? I suspect it does. Okay, cool. Thanks for the invitation to begin with. And some people in this room definitely are aware that the ICO produced the Age-Appropriate Design Code. That was a statutory kind of like code of practice that was part of the requirements of the Data Protection Act 2018 that complements the GDPR framework in the UK. So the ambition of that guidance was to basically provide some steers for organizations that are processing personal data in terms of what considerations they need to have when they're producing products or processing the data of children. We were really glad to see the really recent 5 Rights report that was published this week, actually, that was looking into the impact of regulation, guidance, and legislation in ensuring better design and better practices in relation to children. And that report clearly, at least to us, shows that the Age-Appropriate Design Code, or the Children's Code, as we call it, has had an impact. Now, I just want to talk a bit about vulnerable people before talking about children more specifically. Now, I think it's important to remember that even though the word vulnerable is only mentioned, I think, in recital 75 in terms of the GDPR itself, the whole framework aims to protect people, their rights and freedoms in a variety of contexts when those personal data is being processed. And the fairness principle of data protection actually sits at the core of that approach. And fairness in data protection, and that's a point where we really try to highlight to regulators across the board, both in the UK and internationally, fairness in data protection is really context-specific. So it's not just about algorithmic fairness tests, it's also about considering an individual's position and circumstances, and alongside what kind of data from that individual you're actually processing. And not only that, we updated our guidance on AI and data protection last year, and more specifically the fairness and AI kind of like section, because we highlighted the need to protect individuals, including children. We also launched at the ICO a separate team that is the communities team that actually focuses on looking at the intersection between data protection and vulnerable groups more generally. So that's one of our priorities. And I also wanted to flag that both children's privacy and AI and biometrics are 2 of our strategic causes for this year. And in terms of actually walking the walk and not just talking the talk, we recently established a new AI compliance team as well. One of my colleagues is here, and they're going to actually focus on implementing our policies and making sure that, you know, our guidelines are actually implemented and drives forward that kind of like strand of work. Why the age-appropriate design and considering children's needs are important in the context of AI? Well, we need to consider the fundamentals of data protection, for starters. The data protection by design and by default means that you need to think about what your audience is, who the data subjects are, and put in place all the measures necessary to protect them. Now, children do not have access to all the other levers that data protection has to the same extent that, like, a grown-up individual has. Children, you know, lack the ability. I'm sure they haven't read the GDPR, for starters, most of them, and I'm not sure they know how to exercise their individual rights, for example. And when you're talking about a framework that also relies on individuals exercising their rights, that puts children in a vulnerable position. Because of that position, they never have like a say, there are questions around children, for example, to what extent, I mean, for certain ages, basically, for most children, consent is not really like an option. They don't have an understanding of the information they're getting in order to protect themselves. And also, in our code, we do say that organizations need to design their products and process data in a way that enables children to basically develop their own views and identity, protect them from exploitation, and support their health and well-being along with their psychological and emotional development. So when you're talking about the subject that is like developing, you do need to create a space and environment for them to actually do just that. And apart from any AI-specific risk that has to do with the amount of data being processed, the way data is being processed, for example, you have models that observe an individual's behavior over like a period of time and to make inferences about how the next kind of like behavior will actually pan out. You also have, in the context of generative AI that you mentioned, we see take-up in the edtech sector, for example. And when generative AI and AI is at the core of how you educate children, you probably need to actually think about issues like fairness and privacy and the impact on their development needs from the design stage. So I think there's like a range of issues that come up when it comes to children that it's kind of like we're responsible for dealing with because children just cannot do that. And one of the things we did in the children's code, I think that's really useful in an AI context as well, is that we set our transparency standard and our expectations around transparency towards children. We divided our expectations in terms of like 3 like age groups because we realized there are different kind of like dynamics involved in depending on how old the child is. And we continue to evolve our thinking. We continue to work with other regulators in the UK, like Ofcom, for example. We think they're quite central in ensuring people are safe online. We do support the use of innovation if it helps protect children. Like we recently updated our our age assurance opinion, and we did highlight there that a variety of tools that involve things like age verification or age estimation, they will use AI, for example. And we say that these may be useful tools, but at the same time, you have to evaluate the risks along with the benefits of using these technologies. So our approach is quite holistic. We're not just staying to the on what the children's code can do, but we try to mobilize any lever that's in our disposal. I'm just going to pause here because I think I spoke too much. Yeah.
Thank you, Sophia. It was very interesting. I wasn't monitoring the time, so I don't know if you spoke too much. But thank you very much indeed for that. I think I particularly noted down when you said that children do not have access to all the instruments of GDPR that rely on an individual exercising their own rights, which a child cannot do in the same way. And so it is really critical that the systems be fair by design and default. That was my main takeaway among many other things. So I'm going to turn now to Elisabeth. So Elisabeth, with your very practical experience on data protection and privacy, how much do you see the AI Act in particular being fit for purpose to protect children's rights? And how might its application or interpretation fall back on GDPR?
Thank you very much, and thank you for having me on this panel. And it's really interesting to hear the views of the regulators. And I would say I'm not on the other side, but a little bit on the other side because I'm advising companies and I'm trying to help them navigate all those new regulations that we have, are starting with GDPR, but of course AI Act, DSA, where you also have provisions on minors. And really, I think what I see in practice is organizations, they want to comply with the law. They want to avoid difficult discussions with their regulators. But at the same time, no one wants to hurt children. I think it's very clear that there is this part of you have compliance program to comply with the law and try to navigate it and understand the law. And in that respect, legal certainty is really important. So getting guidelines from the authorities and from the regulators, it's really useful because, to be honest, navigating all the different pieces of legislation is not always easy. You could say, okay, we have the EU AI Act, no, that will help. But when you take the EU AI Act, it's not really protecting privacy. You have to add the GDPR to that. It's not protecting consumer. You have to add consumer protection laws. It's not protecting children. You have to see this EU AI Act in a framework of legislation. And it's very clear in the recitals of the EU AI Act that it's without prejudice of the GDPR, that you have to take into account a UN Convention on the Right of the Child, that you have to take into account consumer protection. So it's all those pieces of legislation that you have to put together to be compliant. And on top of that, if really you want to integrate protection of children in a company, our practices, and in our AI governance or responsible AI governance, you have to go beyond just looking at what the GDPR says or what the EU AI Act says. Because just complying with those requirements, there are some in the GDPR. In the EU AI Act, it's more protecting, in a way, vulnerable persons, and it's very clear in the Act that children and minors are vulnerable people. So it's a very good point, and there are a lot of incentive, I would say, to protect children. But it's more in the way companies will implement their responsible AI governance process internally that would really make it real. So I think it's really important to read what we have in the EU AI Act and to add to that ethical or ethics guidelines, ethical principle of trustworthy AI. And that's really an evolution I've seen in the recent years, where companies had put a lot of energy to comply with the law, to comply with GDPR, but no ethics. It's really becoming very, very important up to the board level, implementing our AI principles, your trustworthy AI principles. And in that respect, I think it's very interesting to read the EU AI Act, because if you look at our first, what are the prohibited practices under Article 5, you have you have one provision that is prohibiting AI systems that exploit the vulnerabilities of persons based on age. And you have many instances in the EU AI Act, even if you don't have a reference to minor or to children, you have a reference to vulnerable persons due to their age, or vulnerable persons below 18. And I think that's really relevant. If you want to put on the market, or if you just want to use a high-risk AI system and you need to do a risk assessment, your risk assessment needs to take into account that there might be vulnerable people impacted. So I think that's really a progress. In my view, there is more about children in the EU AI Act, maybe even more than in the GDPR. But we can have different ideas about that. But it's just a piece of the puzzle. So EU AI Act will just help with GDPR, but you also have to look at DSA, for example, Article 25, and targeted advertising prohibited towards minors. I think all those pieces together, you have to put them as an organization in your governance process, and codes of conduct will help, guidelines will help, just to show organization that also on a voluntary basis, you can increase protection of children.
Thank you, Elisabeth. Indeed, there is a lot out there, isn't there? And I think indeed for companies, like bringing it all together and creating a practical framework that actually, drives their internal practice in the end is key. Otherwise, it is just, doing the minimum for compliance and ticking boxes. And compliance in the end is not in itself the only thing we want. As other speakers have also said, it is not just about the regulation itself. It's about it actually driving change that makes a difference to the practical experience of children. So that will bring me to Ansgar, who I know has things to say about this. So from a corporate perspective, Ansgar, what indeed can drive not just this compliance with the regulation, but ultimately that practical change in the lived experience of children when they're interacting with AI?
Sure, thank you. And yes, absolutely great to hear also sort of the bit of an overview of the many different pieces of regulation, of course, that come to play here. That is not just GDPR, not just AI Act, but also Digital Services Act, and the way in which they all need to interact with each other. Of course, that means any organization that is looking to put out tools, software, applications that potentially minors might be engaging with needs to figure out how to work with all of these and put in place governance frameworks around that. Now, somebody who's been working in this AI ethics kind of space for close to 10 years now, starting as an academic, it has been interesting to see the evolution of this space. It is becoming something that we also are seeing from companies that reach out to our consulting practice in EY that has services around governance and trustworthy AI approaches. It has been interesting to see that the number of companies that are reaching out is increasing. There is a obvious link also, of course, to the new regulation coming in place. But already before the AI Act, there was a steady stream of increase of organizations reaching out because of the growing awareness, because also of the growing narrative within society around the fact that this is something that needs to be paid attention to. However, there is a very big challenge when it comes to the teams that are involved in building these kinds of tools. As was mentioned, they are building it generally with adults as a target audience. The compliance and the risk teams tend to be looking at it from the point of view of what are corporate risks, financial risks, what are physical safety kinds of risks. But if we're talking about the big risks to and vulnerabilities of minors in this space, we're talking about psychological risks. And this is an area that these teams, generally speaking, have close to zero experience in. There's very little feed from the psychology community into the software safety kind of community. And so this is where there's a need to be able to look to standards, some kind of a best practice that industry can refer to and say, okay, we might not know ourselves what is the best way to do, but in a recognized standards body, such as the IEEE, which Five Rights has worked with, CNIL, which is currently tasked to build the harmonized standards for the AI Act, ISO IEC, which is doing a lot of work on AI standards at the international level. One of these recognized standards bodies, which is bringing together experts from across the technical, but also reaching out to the non-technical community to build, sort of what is a good process to follow? What are the steps that we need to be doing? And so one of the valuable standards in this space is a piece of work that Five Rights did together with IEEE, following up on the age-appropriate design code having been published by the ICO, is the IEEE 2089-2021 standard, which is the standard for age-appropriate digital services framework based on the Five Rights Principles for Children, which effectively it gives a clear overview of various steps that you should be taking, when to start doing this across the life cycle of the product, who to involve in the process, the fact that you need to be talking not just to the software engineers, you need to be involving management, you need to be involving even the conception of what it is that you're wanting to achieve with this tool. There is, of course, another big problem, and this is something that Xavier touched on. Children don't understand when they're engaging with AI. Companies don't understand when it is that when children are the ones that are engaging with their AI. And so that touches on this question of age verification. It's also a big issue, of course, when it comes to thinking about regulatory compliance. If the regulation says that you need to follow age-appropriate design when dealing with children, that you need to make sure that you're not collecting data on them for targeted advertising, those kinds of questions. you need to know when it is that you're engaging with a minor. And so this is a big space that is also still in development, and Five Rights is working with IEEE to develop a standard in this space as well, the 2089.1 standard, which is currently draft standard for online age verification, which should help companies to understand what are the various types of methodologies that you can use, including think about what kind of a service you're actually providing. Maybe it's enough to simply ask, do you want to be recognized as a minor when engaging with this kind of tool? Obviously, that depends on what is the kind of risk that the users would be exposed to when using this kind of tool. Now, these standards, they've been worked on with the IEEE. They are for the international audience, so to speak. The EU, with its specific regulations, of course, has certain specific requirements, and we're seeing some of the challenges that come in play there at the moment with the harmonized standards work at CNIL for the AI Act, that things like the ISO standard on risk management could not be directly adopted because there's a different definition of risk. There's different ways of specifying fundamental rights and those kinds of things. And so there's certain elements to that as well in the case of standards for age-appropriate digital services. And so therefore there is a workshop agreement with CNIL, between IEEE and CNIL, to help clarify how to use this IEEE standard in the European context to build out some of these kinds of additional aspects. So this is a little bit of an overview of the kinds of ways in which standards and those kinds of tools can help companies to make sure that they actually can achieve compliance, but also that they can think beyond compliance to say, well, first of all, we recognize the fact that not all of our users are adults. Secondly, we recognize that maybe the challenges that come with that are slightly different to some of the challenges that we usually think about. It's not just about cybersecurity risks. It's about, we're dealing with people at different developmental stages who have, how is interacting with an AI system that's going to respond in a certain kind of way? How's that potentially going to impact their psychological development? Those kinds of things that they need to be thought about. And so therefore, how to position yourself as we are an organization that's actually taking these things seriously. We are an organization that you should feel comfortable to engage with your whole family, including your children, because we have actually taken care of this. And so for that, being able to refer to standards that organizations like Five Rights have been involved in, and the regulators, the ICO, the CNIL, and others have been involved with, can be very beneficial. And there's also thoughts around how to create some certification and accreditation questions around this.
Thank you, Ansgar. Indeed, there's a lot going on in the standardization department at the moment, but I think in particular with the AI Act, there's going to be a lot more. And the question is going to be, indeed, how do we make sure we get it right and that what is there is useful and not just, becoming this enormous pile of documents that, make even more work for Elisabeth to go through and work out what on earth that really needs to be taken into account by companies. So thank you very much for that. I am going to let all of the panelists come back and comment on each other, anything else that, thoughts that have been sparked by each other's interventions, and then I'm going to open to the floor. So you can nudge me if you really want to come in first. Otherwise, okay, go on. So, Sophia's very keen. Go ahead, Sophia, then. I won't ask you anything. Just tell us what you're thinking.
Yeah, no, I mean, when Ansgar was talking, I just kind of I think he mentioned transparency at some point, transparency in the context of how children's data is being processed. And I think transparency is the common denominator around the issues we see right now, I think, across the board. It seems like we're still trapped in this debate or, around what meaningful transparency actually is, whereas like even the baseline is not actually there. And I'm not sure to what extent we can protect children if we have, for example, in the context of generative AI, we have a consultation that's ongoing since January this year. And, we are actually inviting companies to be more transparent around the training data they're using, for example. That's part of the consultation we released a couple of days ago on individual rights, for example. So I do think we should link back, in a sense, everything to transparency, because at the end of the day, if a child is not the one who's going to consent and parental controls will be in place, even parents need to actually understand what exactly is happening to their children's data and for what purpose. And I think that's one of the useful insights that's spotted in the report that Five Rights released in this week. The fact that they found research that engaged with parents unable to make decisions around how their children should engage with services, for example, because they do not understand the impact. And yes, if you don't understand what data they process and for which purpose, you definitely cannot understand what's gonna be the impact on your child, I think. So transparency is something that we really need to focus on. Yeah.
If I may maybe add on transparency, I think it's super important also and of course, depending on your age, it's easier or more difficult to understand you are interacting with an AI system and not with a real person, and we have no clue, as you were saying, what would be the psychological impact on children. And especially with this generation and with people building or developing AI systems, not thinking about that. My son is 17, he's born in the 2000s, so he knew internet, and at school had a lesson on religions. And then he came back and asked me, so God is a bit like internet, he knows everything. But with AI, what are children going to ask about knowing everything? And I think we have to take that into account. And I think it's progressing. A few years ago, when you were looking at privacy policies on websites, that's something we have been drafting in a lot, and you want to be transparent, and of course, depending on the audience, you have to adapt. But many times you just had a kind of a disclaimer, our website is not targeting minors. If we learn that we have data about minors, we will delete them, and that's it. And I think that's evolving, because it's much more difficult to know where the line is. We know the line, it's 18 and you were minor or not, but who is using what? It's very difficult. So we see an evolution in terms of it's just not sufficient to have a disclaimer. You really have to do something.
Just to add something, when we speak with children, they don't speak about God, but we clearly understand that for them, internet and AI, much more, it's magic. It's magic, it's in the air, like the song. But it's not, and they absolutely don't know that. They absolutely don't understand that. Depends on the age, of course. At 17, it's not the same at 8 or 6. But it's something very important. And the question of transparency, the challenge is to make it comprehensible for a child. And what Ansgar said was, I think, very important, is that privacy issues, AI issues, it's not just about the tech guys or the legal officers. It's about everybody. Everybody should be involved. And because I am a legal officer, but if transparency is just the responsibility of legal departments, it won't be comprehensible for kids because we don't speak the same language. So we really have to involve everybody to hear the voice of kids. At the CNIL a few years ago, and we are still doing this, we try to do some workshops with kids about the design of especially the exercise of rights. They don't exercise their rights because they do not know they have rights, okay? But because online it's not very easy to understand and to reach the right form. It's not always in French because they don't use a lot of French social media. And so it's very important to find our way on legal text to be transparent. You could be very compliant with, you could comply with GDPR with a very, very complete legal text, but nobody understands it. So what? So I think it's very important to be aware that our issues are not just for tech or legal persons. Thank you.
Thank you very much. I would say indeed that transparency, I think we can all agree, is critical, but maybe indeed not enough, not transparency towards children about what you're doing, but transparency also from companies about what is being done with this data and how it is being used and how their systems are designed or not designed. I think that's the kind of transparency that is critically missing at the moment. Ansgar, do you want to come back on any of this? Otherwise, I've got another question for the regulators over here in a moment.
I think in considering the time, perhaps best if you go to the regulators.
Well then, I'll try and see if you have anything to say just at the end. But I have one question for the regulators before I also see if anyone in the room has questions, which is indeed, I mean, Xavier, you said, you know, right from the start, data protection is still in play, and yet all of this is coming on top, you know, as Elisabeth was saying, you know, there's all of these other regulations and things, and you know, they do increasingly have a focus on children. So, you know, what are data protection authorities, you know, going to do to make sure that GDPR, you know, is central and is still relevant? I mean, we know that the European Data Protection Board has been working for the last, I think, 2.5, 3 years or something, on guidelines for children's data protection. When can we see them, and how are they going to interact with the DSA and the requirements for a high level of privacy for children in the DSA, for example, and the AI Act, etc., etc.?
Thank you very much. It is a very good question indeed, and I do not have the answer. Writing guidelines with 27 authorities, it's quite a challenge. And it's going on slowly, but I can't tell you that it will be released in this year, next year, I don't know, because it's very, very difficult, but we're working on it, for sure. And yes, the fact that we have GDPR, DSA, EU AI Act, and a lot of different national legislation also, that's not helping. Because I'm sure we know that it's difficult for companies to comply with all these legislations. What's the difference? How do they interact? But it's also difficult for regulators. Maybe I think it's also difficult for the legislator. So that's a real challenge. And after that, the main question is, how can we enforce this text? GDPR and the EU AI Act, they are not just for European companies. They apply to companies outside of Europe. Okay, good. How do we enforce that? It's not so easy. Let's say it depends on the company, or it depends on the country in which the company is. So that's another big challenge. So maybe we need international text, international standards, that show the commitments of companies, that show the commitments of the entire world, and not just only Europe, about these issues. And to make some enforcement, at least at the CNIL, we need complaints. And as I said, children, they do not know their rights, they do not exercise them, they do know how to use tools, but they don't understand how tools works. And so I think I can say we need more 5 rights type of organizations. Because we have, in Europe, we have a big organization about privacy. We have organization about children's rights, but we do not have a lot of organization about children's privacy rights. And I think we need more organization like this. So if you want to create one, just do it.
Hang on, don't create another organization. Come work with us, you know. we can do this, and indeed, anyone interested in working together on bringing complaints to the CNIL, just raise your hand, come see me afterwards. Very, very happy to work on that. Now we have an open door. So thank you very much. We still have a little bit of time left. There's the lunch break in 10 minutes. So if people still have questions, you know, we can stay another few minutes, but if people are really hungry, you can leave. We won't look badly upon you if you leave immediately on time for the lunch break. But questions? Someone? Okay, lunch will have to wait. Do we have microphones? Otherwise, is it... Oh, there's a microphone. Wonderful. We're going to start in the back, because that was the first hand up, and then I note, indeed, a few hands afterwards. Could you please just say who you are, who you work for, and then your question?
Yes, hello, my name is Sarah Roda. I work for an association that represents European doctors. My question was in relation to the fact that manufacturers are the ones who decide on the rating age of a specific product or software. And there was the case of WhatsApp, that until April it was rated for the age of 16 for children, and after April, perhaps because of the AI Act, it lowered for 13 years old. The content did not change, the structure, the functionalities. And my question is, what tools does data protection authorities have to deal with these cases and perhaps revert how a manufacturer rates their product?
And manufacturers do one rating and then app stores do another as well. Shall we gather a few questions while you reflect on that? Because I think that's not an easy one to start with. Okay, I'm going to go here too, and then I'm coming in the back, and then, yeah.
Thank you very much for the interesting presentation. So my name is Elisabeth and I work for Meta. Will CNIL have a role in the enforcement of the AI Act at national level? Thank you.
Hi, thank you so much for the panel. My name is Lynn Høgossen. I work for the Norwegian Consumer Council. And I have a question on actually particular to the consultancies, but also for everyone, because there's a lot of different ways that you can use AI. Some were mentioned, and transparency was mentioned as a solution, but I think there is only so much that you can do with transparency, as Leanda also mentioned. So I was wondering if there's some particular uses of AI that have been, or that are targeted at children, that you have advised companies to not do in the end. For example, there's for many years been a lot of issues that have been raised with the recommender systems that are used in a lot of social media. Also now that there are coming many chatbots based on generative AI, really advertised as friends for children. So whether you could give some concrete examples of when you would ask companies to not use AI targeted at children. Thank you.
Excellent questions. Okay, I'm going to come back to the panel, and then we'll come on this side for the questions here. So what are we doing about manufacturers deciding themselves on the age rating? Then a particular question to Xavier on the CNIL's role in the enforcement of the AI Act. And then I think to the whole panel, but in particular, I guess, to regulators, if you have specific recommendations or have made recommendations about certain times when AI should not be used, or certain features and functionalities that should not be used towards children. So who wants to go first? Sophia?
Thank you. Can I start with the last question, actually, from the Norwegian Consumer Council, because I think, well, the ICO and data protection in general is technology agnostic. So we will never say, do not use this technology, full stop. It depends on what this technology does, how it processes data, what data it has been trained on, et cetera, et cetera, et cetera. And when I was making the point around transparency, transparency is by no means the solution in and of itself. It is just basically one of the, apart from the fact it's one of the foundational kind of like principles of data protection, and it's a legal requirement. If you violate it, you may be subjected to fines. It's also like a really fundamental starting point. Without transparency, you cannot really go that far in terms of compliance or understanding what's actually happening. So yes, transparency is not the solution. It's part of it's a fundamental part of the solution, if that makes sense. In terms of specific practical things that we can do, you mentioned recommender systems. Actually, as part of our children's privacy project, which is one of our strategic causes for this year, we're going to look into recommender systems and children. And this is an area we're likely to work closer with Ofcom, for example, in the UK context. In terms of chatbots, again, we're another team within the ICO is discussing how to deal with this. I mean, we have already, as some of the people in this room may be aware of that, we already looked into SNAP. We took a preliminary enforcement, we issued a preliminary enforcement notice last year, but we just announced that we managed to have an impact there. So SNAP has produced a data protection impact assessment that we believe complies with data protection in relation to children. So we don't shy from actually taking action, but I would also encourage NGOs or groups that have concerns to raise them with the complaints department of the relevant DPAs. And that actually maps onto the first question around what we can do with developers that basically have misidentified the age bracket for their services. It's about kind of issuing, basically reaching out to us and telling us, this company does not actually comply with the children's code, basically, because the children's code has specific requirements around how you evaluate your risks depending. And the age group has an impact on the risks involved as well, obviously. So, yeah, that's all. Thanks.
I'm going to specifically ask Xavier to answer the question to you.
Regarding the EU AI Act, we still don't know what will be the CNIL's role. We hope we will have a major role. We are talking with the government about that, but at that moment we don't know.
Okay.
Maybe I can just add a point on, you were asking if we have seen examples. I think I don't have examples except that I think at the very beginning of our enforcement of GDPR, there was one decision about prohibiting using facial recognition systems in schools. And I think that shows how the GDPR can help. We were not discussing AI at the time, but that was an example. And I think you have to look at the EU AI Act also as it's completely different in the way it's drafted than GDPR because it's more product safety legislation based on a risk-based approach. So you will have the prohibited AI systems. And we mentioned those who would exploit vulnerabilities of children. Then you have high-risk AI system. And in a high-risk AI system, you have all AI systems used in education and like in schools, so I think that will also help understanding what is permissible, not permissible, what is high risk. And of course, the European Commission should come with guidelines to help us understand the different aspects.
Yeah, and maybe if I also touch on that question regarding certain AI use cases that we would say areas where you should not be using AI. Personally, I'm not in the consulting side of the firm, so I don't have specific use cases that I would be able to talk about. I mean, I wouldn't be able to talk about them anyway, but would be able to refer to. But we do have a clear set of principles that the firm itself has established, and they refer back to things like the OECD principles that set out where would we as a firm be, where do we set the line that we say this is areas that AI should not be used for. We have a risk management process that comes into any kind of engagement that we take with the client. So if the client were a prospective client were to be speaking about something that goes outside of these boundaries of our principles, we would not clear this as being a project to take on. We have had conversations where it was more along the lines of how could you mitigate the risks by saying perhaps you don't use the AI to make the decision, but rather you integrate it into a human-in-the-loop process where, and then the question is, how do you do that in a way that is best to make sure that the human retains actual decision-making and isn't just a tick box kind of exercise? So those kinds of conversations do happen.
Okay, I'm going to take the questions here, and in the meantime, I do note that nobody responded to the question on age ratings. So I would say, from Five Rights' side, that indeed, a company has a right to then say, we think this product is appropriate for, this age range, or from above this age. But in that case, that product should be age appropriate, and also under the UK age appropriate design code and under the standards that Five Rights espouses, there are certain things that you would need to take into consideration, and you would need to be able to justify that as part of your risk assessment process, that you have taken into account the risks to various age groups and decided that this was the correct age. And also there's a standard in the age appropriate design code which says you should enforce your own terms and conditions. So if you say that it is appropriate for over 16s, you should make sure that it is over 16s using that service. If you say it's okay for over 13s, then ditto, you should make sure that under 13s are not accessing that service. And again, I just note that there are really different age ratings. When a manufacturer decides one age rating, and then app stores often decide another, and this is highly problematic and confusing also for parents and children. Question over here, please.
Hi, my name is Sarah Brandstatter. I'm a tech reporter at MLX here in Brussels. Thanks for the panel. I have a bit of a different question. I'm sure you're all aware of the CSAM legislation that is discussed right now, and the member states are trying to find their position. And I would love to hear your thoughts on this conversation, or how to bridge the gap between protecting children on the one side and then ensuring also data protection and privacy, and these privacy issues that are really seen as a problem right now, and that's why that the discussions are very stuck. Thanks.
Yes, hello. I'm Clara Stratmann from the University of Duisburg. Essen. Basically, my question has partially been answered even. I was trying to come back to the topic of transparency because, first of all, I really appreciated that Ansgar pointed out that psychology is such a substantial discipline in this research, understanding what people need to know, and especially in terms of transparency. And I think it was Sophia who also pointed out the responsibility of the parents, and that responsibility cannot always be met, that parents sometimes don't also understand what's behind the algorithms or artificial intelligences that their children are using. And there's this big debate about privacy literacy being such a substantial part in children's and youth education, but also the conversation of that means you put the responsibility into the hands of the individual instead of having an overarching institution kind of help with that, and instead making everyone responsible for themselves. And I just wanted to maybe get some people's opinion from different disciplines also, if that's the way to go, if there's a different approach, maybe also from the legal perspective or other perspectives. It's something that has been, as a psychologist, bothering me for the past months, and I would like to get some input maybe. Thank you.
Very, very short question, please.
Hello, hi, Paula Bello from My Data Global, founder of My Data for Children. And my question is as parent. I feel completely disempowered because I see technology moving very fast and legislation not being able to catch up. So what can we do in order to close the gap?
Luckily, we have hours for that. So who wants to respond?
I'll actually start a little bit on that last question. One element, and I mean, this is now even being discussed in, I believe, in France, is the question asked to whether there should be some rules around the age from which you allow children to actually start engaging with these kinds of tools. That maybe you shouldn't be pushing it into their faces when they're 3 years old. So, one is to what age? I mean, this is a challenge for a parent, of course, because your child is interacting with children in other groups as well, and they're having access to these tools, and how do you manage that? But I think part of it is providing the stimulation, the educational stimulation as well as the enjoyment stimulation outside of the technical devices and the screens, and give them space to grow outside of that kind of tech environment. The other point is look at things like the reviews that Mozilla does every year on technology-enabled toys, etc. They assess them as to their data privacy and other kinds of things. Before Christmas, usually they put out that list. And engage with the schools to find out what are they using, what are they doing with this kind of technology. Some schools have been reaching out to use face recognition for paying school lunches. Is this really the direction that we want to be going? So some quick ideas.
Yeah, maybe on the question again on transparency. I think we all agree that transparency is not everything or not sufficient to protect vulnerable persons. And I think that's the idea of the EU AI Act. If you look at the risk categorization, even it's a prohibited AI, so we don't even talk about transparency, or it's high risk, and then you have a lot of requirements, and you have to do your assessment and conformity assessments, and so it's just not about transparency. And the transparency requirements, they correspond to the limited risk AI system. So I think what we recognize is some AI systems are maybe limited risk, and in that case, you still need to have transparency. So I think it's recognized as transparency. It's not just the only thing you have to do. What will be very difficult is to assess when you have a high-risk AI system. Sometimes it will be very clear, but sometimes it will be difficult, in my view, to see whether you fall within the category of high-risk AI or not, or if you can have derogations or an exception.
Okay, thank you very much. I just note that the question on the CSAM, unless you wanted to answer that, otherwise I'll say something on it. Xavier, you have 1 minute.
Very quickly on CSAM. EDPB and EDPS have an opinion on that. So it's the opinion of all data protection authorities within the EU. So I can only tell you to read that if it's not already done. And about privacy and all this issue at school and individual responsibility, I think it's not making every individual responsible of its own protection. It's making children becoming responsible adults and citizens. So as privacy, literacy is mandatory, I think. It should be mandatory, but it can be just that. We have to have all the package, but it's very important to help children to understand what's going on. And very short about technology and legislation, I just want to say that, of course, technology is always faster, but in a democracy, I think it's better. You cannot say something is not legal if it never happened.
I think that's a wonderful word to close on, Xavier. So thank you. Will you please all join me in thanking our panelists, and we hope to see you again.